Hello and welcome to EPR with your favorite environmental enthusiasts, Nic and Laura. On today's episode, Laura and I discuss burnout. We have Fred Wagner back on the show to talk about NEPA, the future of the Supreme Court, and the Cherry Blossom Festival. And finally, speaking of cherry blossoms, the Yoshino or cherry blossom trees were a gift from Tokyo Mayor Yuko Ozaki in 1912. The Yoshino trees are the most common variety of cherry tree. However, there are over 430 species of cherry trees. For example, wild cherry blossoms average about 25 to 50 feet in height. Wild black cherry trees can reach over 80 feet tall, which is absolutely wild. How about that?
Oh, wow. That's cool.
Yeah. Hit that music.
All right. Environmental Professionals Day is April 15th. Environmental professionals include social and environmental scientists, engineers and planners, and public and environmental health specialists, among others. We ask that you please show your thanks virtually to our environmental professionals on this day. Here are some ideas for how you could show appreciation for all that they do. Share this blog on your social media accounts or send this blog to other organizations where environmental professionals work. Share the work of someone you know on social media and tag them using hashtag Environmental Professionals Day or Thank You EPs. Today's episode is sponsored by Venable LLP. Venable is one of the nation's leading law firms. Venable's management reflects a commitment to diversity and inclusion through a broad category of hiring, training, and educational activities. Firm's environmental practice group works with clients across the country on major infrastructure development, including NEPA compliance and resource agency permitting. Venable encourages volunteer activities in professional environmental associations, as reflected by Fred Wagner's membership on the NAEP board of directors. Let's get to our segment.
Burnout is an interesting thing, and we've talked about it on the show a little bit. And there's it's almost like any kind of relationship that you have with anyone, right? That everything ebbs and flows, right? And some of what, can be frustrating and irritating is beyond your control, and some of it is in your control. And so I think there's, even the kind of burnout that you have is important to discuss. Like, is it stuff beyond your control or stuff you can control, or both? So I don't know, that's where I start thinking about it. It's like, what can I control? What am I able to, minimize? Like, I have a certain set of hours that I have to work to get paid. And then beyond that is, me being a kind and generous person. And do I have to do that? No. There's this anxiety and impulse and stress, and it feels like you have to, but it doesn't mean that you do. And sometimes I've caught myself being like, hey, I need a break. I do not have to work an extra 10 hours this week. I can take the time that I would normally need for myself. And it's hard to do, but that's one of the things that I can control. So that's when I think of burnout, that's one of the things I try to remind myself of. I'm in control of some of it, not all of it, but some. So I don't know, Laura, what do you think about it?
Well, how do you distinguish burnout from just everyday stress?
Oh gosh, that's a good question. So, there's lots of different stuff that happens every day, right? Stress is, good and bad stress is still stress. It's all, your body counts it the same, right? So if you have life events going on, good or bad, marriages, death in the families, whatever they are, those things are going to impact you and what's going on around you. And being aware of that is extremely important. You might not feel comfortable talking about it with your, supervisor, but if you're concerned about your work performance because you're distracted, that's something that I think, and you trust your employer, that's something you can do. It's a challenge sometimes because you kind of can get used to the stress where you kind of feel like, oh, this is just how things are, so I'm just going to have to deal with it. And you don't necessarily, it's not necessarily true, but you're making it true. You're thinking that this is the way things are, but they don't have to be that way. And I think a lot of times we kind of pretend or we just forget that some of the stress we make on our own and some of it we don't, but the stuff we make on our own, we can influence.
I'm putting you on the spot on purpose.
I know, right? I feel like I rambled. I was like, oh gosh, I'm talking too long. But, I think it's a really big challenge. I think lots of employers all over the country are dealing with that very specific thing. And, I think the workforce at this point, work-life balance I hear that all the time in a way that I feel like I didn't when I was starting.
I was going to say the same thing. I don't think that when I was first working, that was a phrase that was thrown around too often. Work.
Okay. So, yeah. Now let's put you on the spot. So, all right. Tell me what work-life balance means. What are we dealing with when we talk about
it's one of my favorite subjects because I think that balance, people like to think that it means equal or something.
Yeah, right. Right.
Equal work, happiness at work and equal happiness at home, but that's not at all what balance is. I mean, I always use the example of like a tightrope walker.
Yeah.
Because they're not steady walking across that. Like they're sometimes tipping to one side and then sometimes tipping to another side. And if you put a bag of groceries in one hand, they're going to tip hard to the other side to make sure they don't fall over. And if you put a baby in another hand, you know, and then you put a pile of books in a backpack, like it's a lot harder to balance when you're carrying all these loads, right?
Right.
So like the more things you're trying to juggle, the harder that becomes. But then you also have to think about like this. So this analogy or metaphor or whatever this is, for me, it's like, what are your priorities? So what things could you put down to help you balance better?
Yeah.
Or what things you're not going to put the kid down, right? You're not going to maybe put your job down, but maybe you could get a different job that didn't weigh so hard in one direction or the other. So like for me, balance, and sometimes balance is like tipping real hard on the family side, and sometimes it's tipping real hard on the work side. Yeah. But it's coming back to a center at some point.
Right.
So if you're never coming back to a center ever, so that's like why weekends are so important for some people, because I think that's when they come back to feeling, like, okay, I was tipped over to the work side so hard all week. Now I'm tipping back the other way. But when you're constantly fighting the gravity from one side of this extreme metaphor, then you're, that's when you burn out, right? Because you're just like so tired of holding and lifting this thing on the one side. So I think finding ways to reshift things around, get help. Else can carry the load for a while.
Ask for help.
Yeah.
Like
those things can help with the whole work-life balance, avoiding burnout thing.
Yeah. I think, a lot of times people, it's like if you change jobs or even at the same company, if you just do something different, but you still see the same amount of stress, right? And then you have to ask yourself, is it the job or is it me? Am I doing this to myself? Am I putting the pressure on? It's like, well, I have to get this done. Why? Well, someone told me to. Okay, but why? It's like, well, what do you mean why? And it's like, you don't have to do a lot of things that you say we have to do. And I don't want to say people shouldn't work. I'm just saying it's one of those things that if you need balance, because your personal life is tipping really hard and you're like, hey, I've got to take care of some stuff. I've got to deal with some personal things. You don't even have to say what it is. Just be like, hey, I got some personal stuff going on. I have got to deal with. I'm going to be, for the next month or so, I got to be, cut back some of my hours, my extra time. I just don't have the bandwidth for it. And, that's a scary thing, because everybody thinks, oh, that means you're not committed. You're not interested.
Yeah. I think sometimes the burnout it's a sign, right? It's something, it's a wake up call from your brain or your body that's like, hey, something has to give here. So if you're feeling burnout, you've got to examine it and figure out what that is. Yeah.
And, I think that, we spend a lot of time on the examining yourself side of things. But when you do have, people that you are working for, like clients who are difficult, right? That's different, and sometimes it's, well, we get a new client, right? Or we let that client go if it's really bad and everyone's experiencing the same kind of thing. Sometimes it's just personality conflicts. So you can move people around and have different people work with that person. But if that person is, truly awful, then the change has to come, internally too. And that's a really hard decision for a company to make when it's, if it's a large client, if it's like, if it's somebody who's giving you like, $25, like you're not going to be like, oh yeah, and you're a jerk. Yeah, I don't need that. Thanks. But if it's like, your biggest client, it's harder. And it doesn't mean you can't do it. It just means it takes longer.
Well, one of my favorite things on this podcast is when you and I are talking is watching reactions.
I know. That's why I laughed back there. It didn't make any sense. I'm laughing because I was looking at Sam.
If we take this live, it'll just be Sam. Like you'll watch Sam.
yeah, exactly. Oh, that's too funny. Yeah, sounds good. Welcome back to EPR. Today we have Fred Wagner of Venable, LLP, and our official environmental legal correspondent back on the show. Hey, Fred, good to see you.
Good to see you. It's a new year, a little bit late, but I'm glad to be back on the show.
Yeah, absolutely. And it's a fun time in the DC area. So what's going on there? What's new with you in the DC area?
Well, this time of year in DC, it's all about the cherry blossoms.
Right.
It's all about the cherry blossoms. Starting about February, the Washington Post starts printing its prediction of when the blossoms are going to hit peak bloom. Yeah. And, they update it like every week, depending on the weather or the forecast. And it's important because the blossoms are timed to be in peak during the Cherry Blossom Festival.
Right.
So it isn't just out of curiosity. There's a thing there. You want to have the festival when all the blooms are out, if possible.
Right. Yeah.
Well, of course, what's happening is that between climate change and all the rest, the blooms are coming out earlier and earlier and earlier. Yeah. And sure enough, that's exactly what happened this year. So starting about 2 weeks ago, the Post saying, I don't know, we're starting to see the buds. And there's this very detailed website on the National Park Service where they go through each of the stages of a cherry blossom bloom. And then they have a chart saying for the past 30 years when each phase of the bloom has been reached. And then what does that mean for peak bloom? I mean, it's this whole thing. Yeah. And so we have a couple of really nice 70-degree days, in early March, like we never used to have.
Right.
And the breaking news on the Washington Post was not a Trump trial or Israeli war thing. No.
Right.
Banner headline. Yeah. Blooms in peak. which trust me, in terms of banner headlines, I'd rather have a banner headline like that.
Yeah.
Than all the other stuff. But it was big news because it came a full 10 days before they had predicted peak and a solid week before the festival was even beginning. So everybody was following that. And so I said to Mary, my wife said, let's get down there. So just this past week at literally the crack of dawn, we drove down to beat the crowds and we're there at sunrise for the cherry blossoms. And it was spectacular. It was a great year for the blossoms, but really early. So if those of you who are friends with me on Facebook, you'll go and you'll see I changed my picture to show, the cherry blossom picture with me and my wife, and we're fully decked out in winter gear because it was pretty cold that morning.
Yeah, it was. Yeah.
That morning it was pretty cold, but the blooms were just spectacular. And so it's a really big deal. People are, scurrying down today because they expect some wind and rain tomorrow. So it's see blooms now or forever hold your bloom peace.
Yeah. It's so funny you say that. Like my brother's not an environmental person, but he lives in Arlington, Virginia. He lives really close. They just had their very first kid, a month old at this point. And he told me the exact same thing you did. He's like, the blooms are early this year. So it is a big deal. It
is a big deal. And when you go down there, like we did at the crack of dawn, it is a remarkable scene. So it's not as crowded as like in the middle of the day, but it is already very crowded.
Yeah.
And in and amongst the crowd are brides and grooms in their full bride and groom regalia, including like their gown. And remember, it was 38 degrees that morning. Yeah. But but darn it, they're going to get out there and they're going to take their formal photos and they're going to get the cherry blossoms and then go to the car and warm up, I guess. But they were all over the tidal basin. It was great. And the other big news about the blossoms actually has a big environmental component to it, Nick, which is after delaying for I think over a decade or more, the National Park Service is finally starting its renovation of the tidal basin retaining wall area. Now, those who've been to DC know the beautiful tidal basin circular water right around the Jefferson Memorial, now right adjacent to the Martin Luther King Memorial and the FDR Memorial. But the sidewalk and the retaining wall has been needing repair for years. And they put it off. Finally, they had the money. And literally a couple of weeks after the festival's over, they're starting the project.
Yeah.
And what that means is that we're losing, not permanently, and I'll get to that, 150 of the cherry trees.
How many are there? That's like most of them.
That's about half of them.
Okay. Yeah. Wow.
Yeah. And so they have to be taken out for the project.
Yeah. I mean, yeah.
Yeah. So just so you know, for the audience, your environmental professionals, we were on a NAEP board call the other day, and I mentioned that.
Mm-hmm.
And, I thought, it would be a little chit chat before the meeting started and, get a little, oh yeah, that's nice. I've seen the cherry trees. No, it was, it was like detailed information about, oh, don't worry, Fred, the trees will come back. They grow in 2 to 3 years and there's different genuses of the tree and their health is fine. And like for 5 minutes on this phone call, there was like at least half of the call, people on the call had specific and detailed information about how the trees grow, where the trees grow. Don't worry about the trees, Fred. They'll be back in no time. It's like, I wasn't worried. But I didn't realize that everybody on this call knew so much.
That's funny.
So another benefit of working in the environmental professional field is that you can have more than cocktail talk about the cherry blossom.
Yeah, for sure. That's what we love about NAEP. That's a lot of fun. So,
and then the last thing about the cherry blossoms is that a DC thing. Mm-hmm. Not only do we know the trees, and it's a tradition, we go down there every year, but they name some of the trees because they're particularly famous trees. And one of the trees is nicknamed Stumpy. Mm-hmm. Stumpy. Because he's just a stump. He has no branches, but there are blossoms coming out of Stumpy. And he's like the most famous cherry tree. Unfortunately, Stumpy is about to meet his demise as part of this renovation project. But again, only in Washington, D.C. do you see the cover of the Washington Post, Congress negotiating opening the government, Benjamin Netanyahu and Biden in a dispute, and Stumpy. Like front page news is what you see. So that's another cherry blossom piece of trivia for DC aficionados.
That's great. I don't love that we're losing him, but that's, I mean, like I say, it really is genuinely a very big deal to a lot of people. So I love it. Thank you for bringing that up. And it's a little seamless segue into some of what I want to talk about with you today. And actually, you just sparked a question for me. So you talked about the continuing resolution, right? I think this is our third continuing resolution of the year. Last year, we avoided this. The year before, we did not. Can you talk to is this just what we have to deal with going forward? Is it going to keep being like this? Because it kind of, for what I do, for example, working with the Department of Defense and, Homeland Security, it delays a lot of things and it makes us scramble at the end of the fiscal year. So is that something that we just have to deal with?
Yeah, I think so for the foreseeable future. I mean, first of all, it's a product of, the current Congress, where the margins for the majority are the smallest, possibly in history. And so they have a great deal of difficulty doing anything, never mind something as important as passing a budget. And a substantial minority of the majority are fiscal hawks and are more prone to use the negotiations over the budget to push specific policy agendas. And that's becoming more and more, common. So the folks now that are big on, border security, for example, put in a lot of, riders and additional, specific provisions on the budget to deal with that in particular. Well, that creates a split, like almost immediately. And then, trying to get a majority to pass, when you have a solid, fill in the blank, 20, 30, members who are going to be hardline on some of these things, make it harder and harder. To the most recent continuing resolution that I think just passed today, the Senate should pass it and avoid a shutdown. So I'm sorry, you'll still be employed next week. So you won't get vacation next week. But they did it under a special procedural rule where they needed a 2/3 majority in the House. So that made it even harder, even with Democratic support, because you didn't know how many Republicans were going to be there. And it's a totally different day in Washington. I mean, it used to be, you didn't have a vote until you knew what the vote was going to be. Right. You didn't even start it until you knew. And like for this vote on the most recent CR, they took the vote and then they literally had to do the math. So the numbers were up on the board. You knew who voted yes, you knew who voted no. But they didn't know if it passed because they didn't know how many people voted. And then they had to do the math to see if it was 2/3 and then compare that to the actual vote. They literally didn't know before they voted. So the short answer is yes, it's going to be that way for a while. My sense is that, if the different scenarios in the election, I know we're talking about that today. There's some possibility in certain scenarios where this could be avoided in the future. So if the House flips and the White House stays the same, I think there's going to be a very strong push to do a full 2-year type budget cycle like they should be doing all along. But if there's a split and the House and the White House are different parties and the margin continues to be this close, even if the House flips, I think it's going to continue. Right. It's just the importance of the budget votes has been, elevated so much so that any small number of members from either, the hard right or the hard left of the Democratic and Republican parties easily can use that process to advance specific policy agendas and gum up the works. Right. And, unless there's a major change and the margin becomes 20-30 or something like that for one party or the other, I do think it's going to continue because this becomes the vehicle by which things that otherwise members can't get through ordinary, regular order, as they say, through legislation, they try to attack through the budget. So, you're going to see it more and more. And I'm just like you, you get on conference calls and the client says, well, if we're not shut down, you'll have comments by Tuesday.
Right. Yep.
Or something like that. And I think that's going to be common in your lexicon for a while more.
Yeah, it has been for a bit. We were almost stunned that last year wasn't like that. If that makes any kind of sense, that's just what we expect. It's just kind of funny. And, you mentioned legislation and stuff like that. Like we say, we have an election year coming up and you've been our predictor for a while now. And I think, looking back, your success rate, I think is almost 100%. If it's not 100, it's like 99. So, one of the things you predicted is that we'd have the same exact running mates in this election that we had in the last, and for better or worse, that's what we've got. So one of the things that there's a lot of implications we have for environmental professionals through either case, through either scenario, but maybe the one thing we can do is kind of walk through both. So if we do have a second Trump term or a second Biden term, the implications of those are pretty, you can kind of guess what they are, but let's actually talk through them. So we start with, Trump getting back into office. What changes from an environmental perspective?
Yeah, no, I think it's safe to say that, year in and year out, there's always an expectation that environmental practice would demonstrate quite a big shift depending which party wins. So that's almost a given, right? Given some of the sort of the natural positions that the parties have taken over the years. But for the most part, certainly at the beginning of my career until recently, those differences could kind of happen on the margins.
Yeah.
When you think about it, really. I mean, there were some things that absolutely changed in and out, but for the most part, there was some predictability. And why is that? Because it's the mantra that you've probably heard your whole career, and I've heard, is that the one thing that folks who are responsible for compliance with environmental law hate the most is uncertainty.
Yeah.
All they crave just tell me what the rules are and I'll deal with it, right? That's what they want. And that carries some weight because, people are on different sides of different pieces of legislation or regulation. Of course they are. Yeah. But at the end of the day, they'd much rather have predictability than the pendulum swinging back and forth.
Right.
The difference in this year, and then I'll get to your question about what to expect in a second Trump term, is that the notion of working on the margins is history. Yeah. We're totally in the pendulum swing world. Yeah. And if there is a second Trump term, and again, important for your listeners and important for my firm, Ethics Counsel, this is not a political statement whatsoever. This is just objective truth that there would be a huge pendulum swing on all things environmental policy, environmental law, environmental regulation, climate, if there's a second Trump term. The dynamics that we had talked about over the years, Nick, and now it's been years, I hate to say it, was that the beginning of the Trump term, first Trump term, was absolutely marked by an effort to roll back regulation, deregulate, provide greater flexibility on any number of things, obviously the changes in the NEPA regulations, et cetera. Well, what happened? They didn't do so well. The changes that they tried putting in experienced a remarkable failure rate from a legal perspective. So they make these changes. The usual parties on the other side, the Sierra Clubs, the NRDCs, other groups, challenge those changes. And in a remarkable percentage of the cases, the environmental NGOs won because the administration had not gone through the appropriate steps and process to get all these things through. And I'm not just saying just a little bit more. I'm talking about a remarkable percentage more. They lost. They didn't get it done. And I think even in terms of some of the personnel, I mean, at the beginning of the administration, the folks that you had, the helm of some of the key agencies, not superstars in terms of getting things done. Now, ironically, near the end of the Trump administration, you saw things change. And I think you're more reflective of what you would see in a second term. Right. So, for example, the difference between a Scott Pruitt and a Wheeler at EPA.
Yep.
You know, between a Zinke and a Bernhardt at Interior, right? Again, this is not a political commentary. This is just a factual commentary.
Right.
The gentlemen, and they were gentlemen in both cases, who took over those roles from the beginning of the Trump term, who took over the roles near the end of the Trump term, were far more proficient.
Right.
In terms of doing their job. They understood the bureaucracy. They understood the standards. They understood the law better. I mean, Bernhardt was a lawyer, you know, and they were able to do more near the end of the administration than they were at the beginning, even though they had all the, you know, energy and they had the whole Congress at the beginning of the administration. There was, again, an objective statement. There was a competence factor with some of the initial folks that got better over time. In a second Trump term, they're going to be starting with the folks that are closer to the Wheelers and the Bernhardts of the world, the people that are not only sympathetic with a particular point of view, of course, you know, that you expect to be the case, but also much more competent in getting it done.
Right.
So I think that's going to be a major change, just, you know, from a day in, day out practice. Oh, don't worry, you know, they'll thumper around a while and it won't get, Yeah. I think that people understand what the interpretation is of their view of administrative agencies, what they should or shouldn't be doing, and they're going to do it. And they're going to do it quickly and aggressively. And with, you know, a lot of the judicial appointments from the last term, you know, they've got a fighting chance to see it through. Whereas, you know, the last time, the manner in which they did it, the judiciary hadn't really changed enough for them, and they suffered a lot of defeat. So that's one big thing that's kind of out there. The other thing that we could absolutely expect is, you know, major shifts, if not 180-degree reversal in anything related to climate and climate policy. And it goes beyond just whether they're in or out of the Paris Accords and stuff like that. You know, you can guarantee that they'll withdraw from that. But it's more specific. Now, there's a whole little I infrastructure in place for electrification, decarbonization, the funding of these programs, and so on and so forth. So whether you're talking about the licensing and permitting of wind farms, solar farms, whether you're talking about the expenditures for EV charging, whether you're talking about the EV charging, you know, incentive under the Inflation Reduction Act or something, all those things are going to be up for play. Now you say, no, wait a minute, Congress passed that. They just can't switch it without Congress acting. And the answer to that is no, they can't switch it. But with control of the bureaucracy, they can do a lot of things to slow walk those kind of policies in a way that they feel is more consistent with their worldview. So, for example, a project that, you know, you're very familiar with, the Hudson Tunnel project, you know, between New York and New Jersey. Yeah. The environmental impact statement for that project sat in Secretary Chow's desk for 4 years.
Right.
It was done. It was largely done. And it sat in her desk for 4 years and they wouldn't sign the final record of decision. Change of administration, that was signed and the project's moving forward. You can easily anticipate, and again, you fill in the blank, you know, wind farm approvals, you know, solar approvals, transit projects, anything that may not be favored by the folks that would populate a Trump administration, there will be efforts to slow walk those things.
Right.
And again, there's ways to try to prompt action. It's very but it's difficult to do that. And you know full well of all the administrative obstacles that you have to cross in the best of days. Right. Never mind when somebody's purposefully putting a wheelbarrow in front of you, and then a cone, and then and then a hurdle. I mean, all those things you have to jump through and over, and I think that's gonna happen a lot.
Gotcha.
And then the other thing that's going to happen, and the reason that this is a particularly crazy time in Washington, D.C., is that the current administration is racing to put out all its major rulemaking initiatives.
Yeah.
Sometime before, I mean, some people are saying April 1, some people are saying April 15, but no later than April 15. Why is that? That's because of this thing called the Congressional Review Act, the CRA.
Yeah.
Within 60 days of the end of a Congress, 60 legislative days near the end of Congress, Congress by a simple majority can reverse regulations issued by an agency during that time. At the beginning of the Trump administration, CRA had rarely been used. The Congress under that administration, again, was a Republican Congress, if you recall, I think they applied the CRA over 40 times.
Yeah, that's right. Yeah, I remember that. Yeah.
To reverse a whole slew of regulations. And we went over that. That'll happen again. If Congress flips, and the Senate is much more likely to flip than the House. But all this is in play. And so the administration currently says, we don't want to screw with that. So let's get all these major initiatives out before, again, what's a legislative day and who's counting the calendar? And, your guess is as good as mine because the Congress is hardly in session anymore. Yeah. But in the worst case scenario, they're contemplating April 15 as that date, and anything after that would be subject to the CRA. So they're racing to get all these things out. Now, they could be challenged in court, Nick.
Yeah.
And they are, and we'll talk about that too. Like the SEC greenhouse gas disclosure rule was challenged by 30 different parties in 8 different circuit courts around the country, but that'll still happen, but at least it wouldn't be a congressional majority flip, right? And so, again, a new Trump administration would aggressively look at any of the regulations that came out like right in this time period, in the spring of 2024, to see how it could either stop it, reverse it. Again, they have to be more careful than they were the first time around, in trying to do that, but they will try to do it. The rule that came out 2 days ago, Nick, on car efficiencies, the EV standards and all the rest, the administration made a concerted effort to, elongate the period by which the compliance would be in effect, making it not as onerous. And in fact, some industry folks said, thank you.
Right.
But, we think we could do that, changing the standards to maybe, include more hybrids or more plug-in hybrids as part of the calculation. All that was an answer to industry that said, wait a minute, it's not just EVs. We have all these different ways to find compliance, to reduce emissions. And the administration said, sure, we'll give you more time and we'll include all those things in the calculations. And many people said, oh, okay, we think we can do that. Yeah. It may not matter if Congress flips and the administration flips. Even that may say, nope, we're not going to do that. We interpret that as a mandate, and so we're going to try to change that. The SEC dramatically changed its greenhouse gas reporting rule from the proposed rule, Nick. They totally excluded Scope 3 emissions.
Right.
So remember, Scope 1, what you emit, Scope 2, the power, the emissions from the power that you generate to do your stuff, Scope 3, everything else.
Yeah.
Downstream, upstream emissions, that was in the initial rule. That's out of the SEC's final rule. Yeah. And a lot of people are saying that's good. We don't have to worry about that. Doesn't matter. 28 different parties filed suit in 8 different circuits. And a new SEC, a new administration will surely, and don't call me Shirley, will surely withdraw that rule, right? So that's what we're talking about. So when I say we're out of the working on the margins world and we're in the pendulum world, wild swings of the pendulum is what we would see in those examples and many more.
Yeah. Yeah. And, it's interesting. Before I talk about like a Biden administration and what that would look like a next term there, you mentioned a few of the initiatives that they're pushing out. In this Biden administration, if we can recap it a bit, what have you seen that's worth talking? And we know, for example, the phase 2 draft rules were out there. We'd hoped they had been finalized by the end of the year, which didn't happen.
It's literally any day. I'm expecting it by April 1.
Okay, so that's what I was wondering. I was like, does that make it in the initiatives? And then what else in those initiatives do you expect to see come through?
Yeah, I mean, it's going to be a combination of finalizing initiatives and then seeing what the courts are going to do about some of the initiatives that have already been challenged.
Right.
So, the biggies that we've talked about in the past, waters in the United States, the EPA court issued a very minor clarification rule last year after the Sackett decision. The cases that had been pending but stayed until the Supreme Court did its thing all popped back to life, all of them.
Right.
And they're being briefed right now. And I suspect that there's going to be rulings this summer on the legitimacy of the December 2023 full rule, in addition to the very small minor clarification rule from last summer. So that's not a regulatory thing anymore, but that's the courts passing on what the administration did in that crucially important, area. The SEC rule is another, huge one that I don't think will be resolved right away, because I think it's going to take some time to brief it and all that kind of stuff. But it's taken on added importance because of California's actions on its own to demand that kind of reporting. So now you have an inconsistency between the SEC and California, and then never mind the EU. So that's going to transpire. I think the clean air rules are the sort of the biggest ones that they're trying to rush out now. The power plant rule, the EV rule, and all that kind of stuff. Those are the ones that I think were most important to this EPA. The other areas where you're going to see a lot of action and are in environmental justice, I don't think they're going to do formal regulations, but in terms of like funding and advancing certain programs and answering, petitions on behalf of stakeholders who are claiming that certain states are not running their permit programs appropriately, vis-a-vis environmental justice and Title VI. You're going to see a lot of that. Out of the Department of the Interior now, you're starting to see a rush of agreements and rulings on endangered species and habitat designation. There was a huge one on the famous one, the sage grouse, just recently. Again, that's going to be, they're going to try to rush that out. So at least that there's something out there. Again, it'll be challenged. But, all these areas, Nick, I think, there's going to be this, rush, and then people are going to catch their breath around mid-April, beginning of May, and say, okay, where are we now? I would not expect a whole bunch more rulemaking after that time. But then all the action is going to be with me and my brethren. It's all going to be in court. It's going to be in court. And that's the other thing that's just kind of remarkable in terms of what we're seeing now. Almost automatically, you name the issue. WOTUS, air, GHG, disclosure, name it. Just name any issue. Almost immediately, a coalition of red states and or blue states, depending on the issue, go in together and file litigation.
Right.
The industry folks, it's like, we used to be the ones, my clients of the world. We were the ones that would go out and do stuff, right? No more, because you have these strong coalitions of states led by West Virginia, led by Louisiana, but others, Texas, who almost immediately put together challenges to all these different rules. So you're going to have not only the rules that are pending, but you're going to have a dozen or more major pieces of litigation that are going to be pending throughout the summer into the fall beyond the election. And then whomever wins and takes office in January, they're going to have to deal with that. So you say, what happens if the Biden administration wins? Well, the Biden administration wins. Hooray, we're back. You go back in and, so you dust off your desk. Maybe there's some new nameplates because people will flip. But you say, just keep on keeping on. No. Why? Because let's say the SEC case went to the 8th Circuit. They literally do a lottery. Can you believe it? That's how they pick the court. They put balls in a jar and they pick out the court that's going to litigate the case when there's multiple districts that get the case. It's hysterical. But the 8th Circuit got the case. So the Biden administration says, great, we're going to be doing this. The SEC is going to go forward finally. And then you could have the 8th Circuit in the spring of 2025 saying, not so fast.
Right.
You were arbitrary and capricious. So even if, because it's a very conservative circuit. So even if the Biden administration wins, you're going to witness this dynamic with, okay, we're just going to keep on keeping on, and the courts are going to say, not so fast.
Right.
Potentially. So again, it's almost like a three-dimensional pendulum, Nick. You used to see going back and forth, just depending on who's in office. But it's even worse than that, because it's the pendulum about who's in office administratively And then layered on top of that, the pendulum of which circuit courts or which district courts are reviewing these regulations depending on where the cases were filed.
Right.
And so it becomes even more, difficult to sort of advance these initiatives. So you would think that if the Biden administration goes into a second term, it'll be even stronger. Everything they'll be doing they'll feel liberated, right? And go on steroids. And I don't know if that's true. I think a lot of the dynamic that we saw with these final rules, for example, may actually continue in a second term, which is there's some realization that unless there's some coalition of the willing on some of these initiatives, it just guarantees this pushback and guarantees delay because you just don't know what the courts are going to do. But if you have some glimmer of, we could live with this and we could deal with it, even the courts sense that, right? And there'd be a greater opportunity for them to advance some of their proposals and their policies. But, it's just like buckle up. How do you plan for compliance circa 2025? You don't, unless you want to have like two different plans and then see what happens and you chuck one out the window. And I don't know many clients that like to do that. So very difficult period to try to counsel folks on what to anticipate. But I'm telling you, the swing of this particular pendulum will be as wide as I think you've ever seen.
Oh, wow. Yeah. Wow. So, okay. One of the things that I meant to ask you about earlier, and it is a perfect moment for it. Like I think the judicial conference, please help me if I'm wrong here, was like, okay, we're not going to do, you can't just pick your judge anymore.
Yeah.
Right. So it's changed slightly. Now, I don't know. My question to you is, I know it changes slightly, but you still get to go to a conservative district and find 9 of the 10 judges are fine. So maybe you get the 10th judge, but most of the time you won't. Does that actually, how big a change was that? Was it a big deal or not a big deal?
I think it's only a medium deal. I think the judicial conference and I think the leaders of the conference recognized that just like the Supreme Court is struggling with that, and we'll talk about the Supreme Court in a minute, just like the Supreme Court is worried about its own legitimacy, right? We had 50 years of precedent, and now poof, it's gone because guess what? New judges. Right. Even Justice Roberts has spoken very candidly about, I worry about what people think about the court. If they just think that it's just a matter of who's sitting there and not, a fair review of the law and how it fits, and then we lose the public support. And that's what it's been looking like. Yeah. Well, the judicial conference felt the same way about forum shopping, Nick. Yeah. And they were saying, look, if it's so bloody obvious that you're not only going to, a district court in Texas, but you're going to that particular judge in Texas to get a ruling, and there's no necessary, nexus to the whole issue except that guy.
Right.
People lose faith in the judicial system. They just do.
Feels rigged. Yeah.
And so what they tried to do is say, hey, look, I'm not saying that, there's venue in Texas, but you shouldn't be so pigeonholing it that only one person can get the case. So I think you hit it on the head, which is, look, if you're going to be filing in the Fifth Circuit or you're going to be filing in Texas in the district courts or whatever, you have a much better chance of getting, a sympathetic judge if you're a conservative. I mean, that's why the Sierra Club filed its challenge to the SEC petition in D.C. because they thought they had a better chance than in the Fifth Circuit. So I think it's only a medium deal because I think they were compelled to do something because it was just so obvious what was happening. And it was, reducing people's faith in the court systems. Like, oh, of course, Judge Smith got the case or Judge Jones got the case. What do you expect? Right. Well, that's not good if you're a judge.
Yeah.
If you're in the judge business and you go to a cocktail party and they say, judge, doesn't matter because we know what's going to happen because Judge Smith has the case. Right. That's bad for the judging business because they make their living on, trying to make, neutral views of the law based on the facts. But if it becomes so clear what's going to happen and the rulings are tortured and all that kind of stuff, So it's a medium deal because they didn't eliminate all opportunities for forum shopping. You can still forum shop, but they eliminated the so obvious ones where it could only go to one person.
Right. So, let's talk about the Supreme Court then. You can say the court has been, as predicted, done a lot of the things that we said it would do, based on who's now sitting there. So what is on their list this year? So we still have Chevron deference, which we talked about before, but what else is on their list? What else are we expecting from the court?
what's going on, Nick, and again, it's now become pretty clear that it's not just one issue of administrative law, it's the entire sort of spectrum of important legal issues that affect administrative law. So the Chevron cases will come out, probably at the end of June, because they're very big, and they'll be one of there's a couple last decisions that the court issues. And based on the arguments, there's no doubt in anyone's mind that the principle of Chevron deference will be either eliminated or severely constrained. Yeah. And what that means is, again, it's a further onus on Congress to be specific and clear, because the Chevron deference said, if there was something ambiguous in the statute, we rely on the expertise of the agency to get anything done. So, for example, there's nothing in TSCA that says PFAS. Where's the word PFAS in TSCA? And so a big regulation comes out, the challenge goes, wait a minute, Congress didn't say anything. How could we just assume that's what they meant? And the Chevron principle will, if it goes away, the notion is that the agencies will be restricted from just saying, well, look, this makes sense. It's toxic substances. It's broad authority under the law. Here's, a new substance of concern that we know about. So it just fits, right? Yeah. And the answer is going to be not necessarily. But it isn't just the Chevron principle. It's the Chevron principle in conjunction with the major questions doctrine from West Virginia v. EPA. Yeah. Which says anything that's, kind of really a big deal, we can't just go ahead. Congress has to speak. So those are two sides of the same coin, Nick.
Right.
On one, it's like, this is really big. It could have $1 billion of impact in the economy. So Congress, you better step in. Chevron, Congress, we know you wrote a 1,000-page statute, but you weren't quite clear enough on everything. So we're going to have to wait. Same idea, right? Yeah. What can the agency do or not do without that clear, again, in the minds of certain, parties, the clearest of direction? And then there was a third case that gets less publicity about the statute of limitations to file a challenge under the Administrative Procedure Act. So a party who is adversely affected by a particular regulation in 2024, a case that's under consideration right now by the court, even if that regulation was finalized in 2000, 24 years ago.
Yeah.
Under the theory before the court right now, that party adversely affected today could still challenge the regulation on its face. That's remarkable.
Yeah.
Now, you might say, well, that's kind of unfair. New company gets formed and they have to deal with this regulation. It's unfair. They have no recourse. It's terrible. Mm-hmm. But then the question becomes, then when is a regulation ever final? Like, right. When can we ever rely on this? But that's in front of the court. So everything related to how an administrative agency works is in play.
Yeah.
And it's going to get harder and harder and harder to regulate, even in the ordinary course. It's going to get harder and harder to respond to, kind of emergency, kind of, the type of situations, Lake Erie's on fire. Let's regulate, right? No, it's going to get harder and harder to deal with that in the ordinary course if you're an agency. It just is. And the Supreme Court is going to severely change how agencies function, all agencies, on every topic, not just environmental law, in the future. So it's a sea change. It's by far the most important time in administrative law, since I graduated law school. And it's going to force a reckoning on how agencies deal with not just rulemaking, but how they enforce existing rules.
Yeah. Yeah. So from a practical standpoint, like, how does that change like the day-to-day work? Because I try to wrap my brain around it. It's like, do we do what we've been doing when we have this pendulum swing? We do things slightly differently. We had cumulative effects, for example. It quote unquote went away, then came back. But the course of that was still pretty much the same. Advising your client saying, yeah, it's gone, but it's not really gone. Is it more like that? Or is it more like, okay, this is a new order. There's new business. We are no longer going to be able to do what we were doing. We have to do a new thing now.
I think it's more of the latter. And here's why. Yeah. Because any one particular company, client dealing with any of these regulations doesn't control the field.
Right.
So if there's an entity out there that feels that the same regulation that you and your client say, I can live with this. It's what we talked about earlier, some certainty, right? I can deal with this. I know what to do at least.
Yeah.
And I'm going to do it. And it's not particularly onerous perhaps, and I can get it done. and I know how it works. Let me just do it. They may feel that way, but there will certainly be members of the same industry across the country in a small office that you don't know who are going to object, and they're going to sue, and they're going to challenge, and they're going to use the major questions doctrine, and they're going to use a revised Chevron principle to say that the agency overstepped its bounds. They're going to use the statute of limitations, say, hey, remember that regulation that we hated from 30 years ago? Let's challenge it now.
Right.
You know, and that's going to happen. And so it's almost the worst case scenario, I hate to say, which is just like you have with WOTUS right now, where you have like 27 states that are under an injunction and 23 that are not. So the 2015 rule applies in half the country and the 20 blah, blah, blah rule applies in another half of the country. That's going to happen more and more. And so you're not only going to have to know, okay, let me look at the CFR and see what's going on in Washington, D.C. You're going to have to look up what's going on in my particular district court, my particular circuit. Yeah. You know, and God forbid you're a company that operates across state lines and you're two circuits.
Yeah.
This is going to happen more and more. And I wish I could be more optimistic. And in some ways, as a lawyer, you know, some lawyers be clicking their heels. You know, it's like, you're full employment forever.
Right, forever,
You know, but that's going to be, I fear that's going to be the trend, which is even if a substantial majority of a particular industry says, look, we could live with this definition, it's workable, we have a sense, let's just move on with certainty, you know that there's going to be another percentage of the industry, could be a smaller percentage, we don't know, who's going to challenge that even so, and then, you know, put things all up for grabs, you know, once again. And I think that's what's going to happen. And it's going to happen on the 30,000 foot level, which is, you know, challenge to a regulatory program. And as regulations are applied, it will apply on the 5,000 foot level to a particular enforcement action, a particular prosecution or civil fines, you know, very, very specific. It'll happen both ways. And then it's going to be up to your companies and consultants to try to track it and understand it and give clients the best advice they can in a particular place. It's going to be up to, you know, me and my colleagues to try to assess the legal risk if a company wants to, you know, do something that's a little bit different or what have you. And it's going to be harder and harder to keep track of it all because it's going to take, I mean, gosh, you know, a decade or more for the new world of post West Virginia EPA, post Chevron deference, post, you know, APA statute of limitations to shake out, to see how it's all going to play out in courts. It's not going to happen right away. It's going to be over a generation. And eventually, I think it will shake out a little bit. I think the legislature will get a little bit more adept at giving clearer directions when they want to do something. You know, that pendulum will change where they'll actually be able to do something on Capitol Hill, not soon, but it will. It just inevitably will.
Right.
But
industry will demand
it's going to take time.
Yeah. Industry will say, "Hey, you've got to do better," and then I'm hoping at least that's what will happen. The industry will push some of that forward. But maybe that's my optimism.
Well, it's not just optimism, Nick. I think it's you're a student of history,
right?
You know, and things shake out that way a little bit. And I think I gave a speech the other day on environmental justice and, you know, the impact of the Students for Fair Admissions versus Harvard case,
right?
You know, pushing back on everything related to diversity and all that kind of stuff.
Yeah.
And I think my line was, every action has a reaction.
Yeah.
Every action has a reaction. And now we're living in that world, in the civil rights diversity world, we're living with the reaction to, you know, admissions policies and diversity policies and DEI and all that kind of stuff. And so now we're dealing with all that. And you know what's going to happen? There's going to be a reaction to that. Right. And then it's going to shake out how these things are going to happen. So the same will be true in our field, but I do believe pretty strongly that the import of what we're going to hear from the Supreme Court about how administrative agencies work is going to require a rethinking of a lot, and it's not going to happen right away.
Yeah, I think that's very well said. And so, like I say, it just means that you and I get to talk more about plenty of things. That's there's plenty.
And like I said, I hope I've stressed that none of these statements are meant to be, you know, one way or the other politically. It's literally as I think you've presented it, Nick, which is, so what happens? Regardless of what happens, how do we deal with all this? You know, and I hope people take it for what it's, you know, that was the spirit in which all that was intended.
Oh yeah, and I feel the same way too. And I think it's so interesting. It's almost some of this is going to happen regardless of who's in office, and some of the way we have to change is going to happen no matter what. And I think,
and never mind the market.
Yeah, exactly.
The free market may still rule. Oh, we're going to slow down the rollout of EV chargers. Well, maybe not. If 50% of the vehicles being sold before you know it are like that, consumers are going to demand it. Regulations be damned.
Right. Yeah, and they'll get built.
And they'll get built.
Yeah. Well, I say we're close to time.
I wanted to put in a pitch, if I could, near the end of time, Nick. Again, we're still working under the umbrella of our friends at NEEP here.
Of course.
But, I'm going to be at the annual meeting coming up in May in Minnesota. I think you will be too. And I hope to see a lot of folks there. But I am this close. I'm almost done putting together a panel that if you're thinking about coming to the meeting, maybe you should think about signing up, because I'm going to have a panel that should have the leadership of the Federal Permitting Council, Council on Environmental Quality, and the Advisory Council on Historic Preservation all on the stage at the same time. And if it can work out, and again, I'm crossing my fingers and toes, but if it could work out, I think it'd be the first time that NEP's ever had that combination of folks up on the stage at the same time. So, it'll be a great candid discussion about, permitting reform, getting projects done, project delivery under the new regime of, new laws and regulations, trying to figure out what works, advice for people in the field who are dealing with these issues day in and day out. So, for those of you who are thinking about signing up, haven't quite yet decided, hopefully that'll come through on top of all the other excellent programming and presentations that'll be. Our case law update will be there again. So, please, I hope people will think about Minnesota and look for announcements on the website if we confirm that session.
And it's going to be incredible. Like I say, I'm super excited about that. That was really, really cool to see. And I love that that's happening. So, thank you again, Fred, as always. And we've got to get you at least one wrong prediction out here. So I know the NCAA tournament's going on. We've got,
I picked Wagner to go the whole way. So already there's a prediction.
There we go.
They won one game.
Hey, that's great. That's great. So we know he's not perfect, folks. There you go. Thank you so much, Fred. Really enjoyed it.
All right, man. As always.
That's our show. Thank you, Fred, for joining us today. Please be sure to check us out each and every Friday. Don't forget to subscribe, rate, and review. See you, everybody.
Bye.